Hello, I'm Dr. Terry Susan Fine, Content Specialist for the Florida Joint Center for Citizenship, which is part of the School of Politics, Security, and International Affairs at the University of Central Florida in Orlando. Welcome to our Middle School Civics Highlights series. Today we look at benchmark CG.3.3, describe the structure and function of the three branches of government established in the U.S. Constitution. In Part 3, students will identify the general powers described in Articles 1, 2, and 3 of the U.S. Constitution. We ask the question, what are the general powers described in Articles 1, 2, and 3 of the U.S. Constitution? We will now focus our attention on Article 1 of the U.S. Constitution, which focuses on the general powers of Congress. Article 1 takes up more than half the space of the entire Constitution. There are 10 sections to Article 1, and it's important to compare the length and the breadth of Article 1 to other articles of the Constitution, such as Article 7, which is just a single sentence, but that single sentence is the information on how to ratify the U.S. Constitution. So that means that Article 7 was used just one time. But Article 1 is used all the time. Article 1 represents what many people argue is the most powerful of the three branches of government. In Article 1, Congress is given the power to collect taxes and the power to coin money. In the United States, there is one currency, and the power to coin that money is held by the United States government. So a few years ago, you might remember that there were $2 coins that were issued, and that was up to the United States Congress to do. The United States Congress also decides whose face appears on different bills and on different coins as well. And certainly there's been some interesting ongoing discussions about whom to honor based on the coin that they might appear on, whether or not, for example, they should be a former president. Not all printed money includes the face of a former president, such as Benjamin Franklin, who was never president. Congress also has the power to make laws on immigration and to make laws on trade. So that means that it's up to Congress to develop and pass laws that relate to these two important issues that have foreign policy consequences. The United States immigration policy is going to affect its relationships with other countries, as will its trade policy, who our trading partners will be, whether or not additional taxes or fees will be added to those trading partners, which then affects who can sell goods in the United States and whether or not there are additional fees and costs or taxes added to the cost of those items. And some people say that's a way of making US-based products more competitive because products bought from overseas might be cheaper to make and thus then might be cheaper to buy. So Congress passing laws on immigration and trade does indeed affect U.S. foreign policy. Congress also has the power to create an army and a navy. So Congress has the power to create and establish different units of the military. The U.S. House of Representatives has the sole power to impeach public office holders at the federal level whom they believe have not performed their duties correctly. And the Senate has the power to remove those officials once they've been impeached. It is very, very rare for a person to be impeached, and it is even more rare that a person is removed from office by being convicted of the charges brought against them through the impeachment process. The Senate also has the power to confirm presidential appointments. So the president makes appointments to their cabinet, to ambassadorships, and to the U.S. Supreme Court, as well as to the circuit courts and the federal district courts. Article 2 includes the general powers of the president. The president has the power to enforce laws. The president is also the commander-in-chief. This means that the president can use his power to send troops into combat, although Congress has passed laws to limit how the president may use their commander-in-chief power through the War Powers Resolution, which was enacted in 1973. The president also has the power to make treaties with leaders of other nations, but making a treaty doesn't ensure that that treaty goes into effect. Whether a treaty goes into effect is up to the U.S. Senate. So the president can negotiate the treaty, but the Senate can say no. And this happened to Woodrow Wilson at the end of World War I. President Woodrow Wilson negotiated a treaty with other countries to form the League of Nations. And when the League of Nations was presented to the Senate for its ratification, this treaty, the Treaty of Versailles, was rejected by the Senate. So even though the president was the one who represents the country in foreign affairs, the Senate has to ratify that treaty. So that power to make treaties is unlimited, but the power to have those treaties go into effect is highly limited by the Senate. The president also has the power to nominate people to serve in the cabinet, the Supreme Court, and other high government positions, but again, it's up to the Senate to confirm those positions. And then the president also has the power to grant pardons. However, granting a pardon, meaning taking a person's conviction away, even if they're sitting in prison for a crime that they've committed, they can be pardoned, but the crime must be a federal crime. The president cannot pardon people if they have been convicted of state or local crimes. One limitation on the pardoning power is if somebody has been impeached, they are not eligible for a pardon. Now we're going to look at the general powers of the courts. The general powers of the courts include two general groupings of powers. One of these is the power of original jurisdiction. There are specific arenas of conflict that the Supreme Court is the very first court to hear a case. And that means that the court is the original court to hear the case, and whatever the Supreme Court says goes. Some of these cases include ambassadors, maritime or naval issues, arguments between two or more states, and issues that involve the United States government. So if we think about it, if there are two or more states that are having a conflict, who can resolve that conflict? Because there may be some concerns about favoritism towards one side or the other if a district court were to try to resolve that issue. So the U.S. is the court of original jurisdiction when there is an argument between two or more states, such as an argument over water rights. All other cases not listed in number 1, the power of original jurisdiction, come to the court through the appeals process. And that appeals process occurs when the Supreme Court hears a case that has already been decided by a lower court. Now, because that decision has already been made at the lower court level, the U.S. Supreme Court does not need to accept that case. And in fact, there is a historical pattern that the U.S. Supreme Court accepts about 1% of the cases that come to it on appeal. And because it's limited to 1% by the Supreme Court itself, the Supreme Court could accept all 100% of them, of course. That means that the court has decided when they accept the case to hear that it might have a significant enough national impact that they should have the final say on it. So the court is usually asked to hear about 7,500 cases a year, and they usually accept about 75 to 80 cases a year. So the Supreme Court has no question on original jurisdiction. They don't have any choice as to whether or not to accept an original jurisdiction case, but they have all the choice as to whether or not accept an appeals case. And guess what? They use that power with great magnitude, such that they reject about 99% of the cases that come to it on appeal. Thank you for joining me for Middle School Civics Highlights. If you still have questions, please contact us using the information that appears on the screen. Till next time, I'm Dr. Terry Susan Fine. Thank you for joining me.